And welcome to another edition of Q&A Social Security Disability Today. I am your host, Anthony Reeves, and this show is proudly brought to you by the Reeves Law Firm, dedicated to representing the disabled and discriminated, the Reeves Law Firm. I want to thank all of you for bringing forth your questions. We're going to try something a little new today. Hopefully you'll enjoy it, and more importantly, hopefully it will provide you with some additional assistance in looking through the questions that we have to provide today. Okay. Of course, the question that was asked was, what does it mean when you're at the hearing level and you're informed that your case is closed and that a decision has been made? Is that good? Is it bad? What does that mean? Well, this is what typically happens. When you have a hearing before an administrative law judge, the judge renders a written decision. Once they put that written decision together, they will then send you a copy of that decision in writing. This way, I tell people all the time, this is the document that either gets you paid or which you can rely upon if you're deciding to appeal this case or file a new application. So what typically will be in the decision? Well, first and foremost, there'll be a couple of pages, which will be your standard cover sheet pages. One, it will tell you whether it's a fully favorable, a partially favorable, or an unfavorable decision. It will tell you that you have within 60 days from the date of that decision to appeal that decision, should you desire to do so. It'll also tell you that on occasion, the appeals counsel will do a review of the decision on its own, meaning they randomly will pull decisions and they will pull them up to see whether or not they think this decision is one that needs to be reviewed again by the court, their reviewing court, and then send back. After those first 3 pages, if you have a representative involved, typically there will be a page on there that lets you know whether they approve the fee contract or don't approve it. That usually happens if you've gotten a fully favorable or partially favorable. Then after that, you have the bulk of your decision. This is the part that lays out in detail the rationale by the judge to render the decision. There'll be a few jurisdictional things at the very beginning in terms of how they got there, when you applied, type of application you applied, how many times you got denied, the hearing itself, and then boom. Then they lay into the decision where the judge actually goes through the 5-step sequential evaluation and gives you a breakdown as to the rationale for making their decision. Typically, if there's any issues in it, they'll put that in there as well. And at the very end is a kind of a summation, kind of a conclusion of how they came to their decision. Now, I tell people all the time, when you get first of all, when you call Social Security and they say they've made a decision and they've closed the case, they're not going to tell you over the phone. I'm just going to be blunt. Now, if you haven't gotten the decision within a few days after them telling you they mailed it to you, you might want to call them back and ask them to mail you another one. But the reality is they're not going to tell you the decision over the phone. The reason why is because that written decision is designed to give you a detailed breakdown of exactly the reasons why they did what they did, or the reason why she or he made the decision that they did. So this way, if it's an unfavorable decision, you'll see where the problem areas were in your case. So that if you're talking to your representative and you're deciding whether you want to appeal it or just start all over again, you'll know what the rationale is. Same thing if it's a fully favorable or a partially favorable. The court is going to give a breakdown as to where they got their evidence or what evidence they relied on to make that decision. Now, I tell people all the time, just because the court has made a decision within a specific period of time doesn't mean anything. So if the judge makes it fast, doesn't mean you've been denied. If the judge makes it slow, doesn't mean you're going to get approved, and vice versa. Just note that written decision, keep that handy so that if you decide to appeal it, or if you're looking for a representative to help you with the case, that's what they're going to rely on, because that is the document that either pays you or you can rely on to appeal. I want to thank the person who provided me this question, who was asking me about what do I do if I think my representative is causing a delay in me getting my disability, meaning the representative is causing the delay. I've been doing this for almost 10 years, and I remember within the first year of practicing, I had someone who made the comment to me, well, I know it's worth your while that they take a while to approve me, because that means that's more money for you. And I was mind blown when I heard that. But the employer that I was working for at the time, he really gave me a nice breakdown, and it's been pretty much the foundation of how I articulate today. First and foremost, I can't speak for non-attorney representatives because I'm not a non-attorney rep. I'm an attorney representative. Most people fail to realize that a couple things you need to keep in mind. First of all, we are bound by our various bar organizations to maintain a certain level of ethics, meaning we can't do anything to hurt your case. Meaning if we have reason to believe that there's evidence that we have in order that would get your case approved faster, we are ethically bound to do so to help. We can't hurt your case. Secondly, one of the things I tell people all the time is that 10% of the population causes 90% of the problems for everybody else. So whenever I hear somebody come up to me and say, well, really, you representatives, it's really to your benefit if we drag this along, I look at them and say, what representatives are you talking about? Because I've never met any attorney that does that, because that's not good business practices. Why would you do something that's going to hurt your client? Because guess what's going to happen? When you do that, guess what your client's going to do? They're going to tell everybody that they know that you did that. So that's a bad business practice. So that's the second thing that I share. Third, as a representatives, we're in a very unique position because we're in the middle. So we're dealing with the client and we're dealing with the government. And sometimes what happens, and this is why the government always encourages the clients to contact their reps first, because it's easy to put pieces of information together and not have the whole picture. And that's why I'm very quick to tell people, before you make an accusation that your representative is taking a course of action to the detriment of your case, you better make sure you have proof, because that's a serious allegation to lay on any representatives. Fourth, keep in mind, at the end of the day, there's nothing in the Social Security regulations that requires a representative to do any particular course of action. Here's what I mean by this. Meaning, if you get denied, they're going to appeal the case for you. If you got to go to court, they're going to go to the hearing with you. A lot of times what happens is there'll be all these medical records and they say, my rep won't get them. I say, well, keep in mind, the regulations say you bear the responsibility of proving you're disabled. I know some representatives take the practice where they require the client to get the medical records and provide them to them, and then they'll provide them to the Social Security Administration. It just depends on the firm. The reason why I share this is because this is something particularly passionate to me, because I always say 10% of the population causes 90% of the problems for the rest of us. It's very easy when you're dealing in a process like this. It's a long process. It's a frustrating process. And it's so easy to believe that things that are occurring to your detriment. This process is inherently slow. I got to give credit to Commissioner Astrew. He and the Social Security Administration are doing an awesome job of trying to speed it up. And more importantly, they're working very closely with the National Organization of Social Security Claimants Representatives, as well as other trade organizations, to ensure that claimants are getting the most effective and most efficient mechanism of processing their claims through. I share this with you to say this. The process is slow. They're trying to speed it up. Be very careful about leveling an allegation, because and this usually what happens is that you have a few pieces of information and then you take that information and you make a bigger conspiracy than what it really is. Be mindful, because especially if you have a representative, if you believe your representative is doing something like that and you bring that to their attention, you're going to see a response from them that you're probably not going to like, because in essence, you're basically telling them they're being unethical. No representatives like to be told that. And if they believe you believe that, that puts you in conflict with them. They may be inclined to withdraw. Now, am I saying that they will? Not necessarily. A lot of times, and I can tell you I've done it for years, I've had clients who've had that same impression. Once I've sat down and explained to them what is going on in their case, they usually feel better. And you know why they normally feel better? It's because in most instances, they've only got one side of the story. They've got their side, meaning they call Social Security told them something, and instead of giving their representative the benefit of the doubt to find out the other side, they just took their side and they ran with it. Be mindful. Most Social Security representatives understand one fundamental point. This is a frustrating process. It's going to take a while. They're going to do everything they can do to help you out. They are not here to be a part of the problem. They are here to be a part of the solution. All right. Again, I want to thank you for joining me for another edition of Q&A Social Security Disability Today. For those of you who have sent me free claim evaluations, I want to thank you. Please pay close attention to your spam box, because a lot of times what we do is when we get those responses, we'll email you if we can't call you. And sometimes we know that sometimes our emails may go into your spam. So if you see something there, respond back, so this way we'll know that you got it. All right. Again, this is Anthony Reeves. This is, again, your Q&A Social Security Disability Today.